How to prove paternity in the Russian court? So, to prove your paternity in the Russian court, you must. First of all, it's to pay fees for about $5 and file a lawsuit in the Russian court in which it is enough to describe the circumstances of the time period of acquaintance and communication with the mother of a child. Second step, court will appoint a DNA test for which you will need to appear in person, and besides that you shall pay about $800 for expertise. Third, the DNA test confirms your paternity. The court will make judgment in your favor. Then you should submit it to the Russian registry office in order to register yourself as a father. So the whole procedure will take about 6 months, and you will spend about $1,500 in total on legal costs and taking into account the cost of a lawyer. By the way, the residence of a child with a Russian citizen is the basis for a foreigner to obtain a residence permit in Russia. At the same time, alimony of at least $400 per month for one child may be collected from you. How to prove the rights to communicate with the child if one of parents interferes with communication. To prove your rights to communicate with your child in a Russian court, you must first file a lawsuit with the Russian court, which must be accompanied by a birth certificate of the child, as well as receipt for payment of the state fee of about $5. Second step is to ask the court to appoint a psychological and pedagogical examination in which experts will observe your communication with the child and his psycho-emotional state when communicating with you. Third, based on the result of this examination, which you will have to pay in the amount approximately $800, the court will decide how privately and where you will communicate with the child. For example, once a week or a month, and in your place of residence or the apartment of the mother of the child. By the way, starting from the age of 10 years, child can be interrogated in the court so that he can express his opinion about possible communication with the parent. So the whole procedure will take about 4-12 months and will spend on legal costs a total about $2,000. Let's discuss disputes about child's residence cognizance between countries. How to determine cognizance of disputes about residence of the child between courts of different countries and Russia. So, main rule, the case will be heard in the court of the country where the case started earlier. Why? First law, Russian Civil Procedural Code, according to which if the foreign court already passed the decision, a Russian court refuses acceptance of the lawsuit or stop proceedings. In a case when proceedings in a foreign court are only initiated, Russian court returns the lawsuit or leaves it without consideration. In both cases, it is necessary that the judicial act of foreign court was subject of recognition and execution in Russia. One more law establishes the same rule is the Hague Convention in jurisdiction from October of 1996 that is ratified by the Russian Federation in August 2012. And took legal effect in June of 2013. Article 5 of the Hague Convention tells the judicial or administrative authorities of the contracting state of the place of ordinary residence of the child possess jurisdiction to take the measures directed to protection of the personality of property of the child. Thus, the general rule is the principle of the first parent who took legal actions, but this location has to be chosen at the place of residence of child. I wish you peace in your family. Bye.